Our next session is a case study presentation on a very interesting topic, legal tech and online brand protection. To discuss this, I would like to welcome on stage Sergey Medvedev, partner at Gorodissky.
Thank you very much for the invitation and opportunity to speak today with you. My presentation concerns the legal tech and online brand protection, and especially why this should come together, especially nowadays when internet sales are growing, when there are a lot of marketplaces and e-commerce going on, and sometimes lawyers they cannot quickly run after different infringers, and they must work together with a software that can, in the automatic regime, help to enforce different infringements. So this slide shows different types of infringements, especially counterfeits, parallel imports, phishing, and infringements in domain names. And the clients, when they come to you, they say, okay, we want to clean the internet, we want to tackle with all these problems. And the lawyer, when he starts working, he just don't have enough of hands to stop one by one and bring a positive result to the client. And we started to search for something new, especially when there are machine learning systems and AI, and wanted to find an appropriate software that can quickly monitor this, quickly fix the evidence, and maybe send some takedowns. So next slide. For example, take the social media. This recently has become a platform where there are different accounts and physical persons, not even businesses, they create their accounts where they can offer and sell different products, different counterfeits. And if you, for example, send them a cease and desist letter, they can stop but open a new account, and this will be a problem again. Marketplaces is also another problem, because marketplace is a big shop where different brands, not even one, is being offered and sold. And in marketplaces you can see a mixture of original and counterfeit goods, and usually they, even though they have abuse report system and special dispute resolution mechanism, it still may be a problem to fight against trademark or copyright infringements with them, especially when in many countries they will have some conditions to avoid liability. Because, for example, in Russia, they can be liable if they have a guilt. So, for example, you send a cease and desist letter, and the marketplace is not doing anything with that, so he can be liable. But if they provide sufficient and necessary measures to stop, then they can avoid infringement. So the first problem that comes here in the table is monitoring. The client, they don't care about monitoring. They say, okay, we want to clean the internet, so please prepare a report. And again, the first thing is the software, which can use different mechanics and techniques and find different infringements on the internet. You want to prepare an abuse report that you want to discuss with the client which particular infringements they want to pursue. The problem with monitoring, you cannot do this by hand. For the lawyer, it's not just impossible. So that's why you have to find a solution, a software which will help you. when working on IP enforcement, this will be a standard mechanism how it will work. You will usually start with Cease and Desist letters, which you're going to send to different addressees, including domain name, administrator, internet service provider, seller of goods, probably registrar. In many countries, registrars can also be regarded as online intermediaries, and they can also be liable. And in many cases, these solutions, I mean the software platforms, they will provide with such an option to send these letters, and they will work. But in many cases, this will not be a 100% result, because there will still be about 20 or 30% of infringers that are more aggressive, and they will not stop. In this case, you can start an offline enforcement, including police raids if it comes to the shops, including customs recordals if it comes to importation of goods, criminal prosecution, or even civil lawsuits where you can claim compensation. But again, when comparing all these kinds of providers, we noticed that global providers, they work more on sending the letters without any further reaction. So they will just prepare and send cease and desist letters to all that addressees which I mentioned, and then they're gonna stop. But local providers, in addition to some features, for example, a language or cultural issue, they can provide further assistance, including negotiations with the infringer, including collection of evidence, and also bringing lawsuits or starting criminal prosecution or other enforcement matters. So again, there may be some local marketplaces which have their own abuse report system, and the global providers, they won't be able to join it or to help with it because they don't hire lawyers inside of the companies. This slide shows different features which, for example, you can encounter in Russia. So first of all, this is a language issue, because if you send the letter in, for example, in Latin or in Arabic, your letter will be ignored because the state language in Russia is Russian, so it has to be in the local language. The same is with a court or law enforcement agency, so you have to apply local language. Again, global platforms, they are usually sending the letters in English. Power of attorney, for example, the respondent or the addressee, they will always ask for power of attorney because they want to understand that if something is said on behalf of the company, there have to be a proper competence confirmed. With global providers, they would usually send the letters without attaching any power of attorney. Sometimes for the court, the C&D letters must be delivered, and you have to confirm as a further plaintiff, you have to confirm the fact of delivery. Otherwise, how the infringer would know that they must stop the infringement. And this confirmation of delivery must also be disclosed to the court. So this, of course, there are many advantages of why we should fight with the infringements online. You will probably ask, so why should we do it? Of course, first of all, it's the growth of authorized sales, because if we don't fight with counterfeiting, there are going to be a lot of flows of it, and your brand will be blurred or diluted, and a lot of counterfeit products will substitute the original products. Take the brand reputation. The more original goods and goods of good quality you provide, and remove counterfeits from the market, the stronger reputation your company will obtain. Protecting the relations with the distributors, because sometimes it is very important to keep this net of distributors, and if they are attacked or the original company is attacked, this net can be lost easily, and this will diminish or decrease the number of sales. At the end of the day, you will get the faster ROI. So IP, we usually say that it's more about protection, but IP, it's not only about protection, it's about enforcement and at the end of the day, commercialization, because it's connected with the product itself, with its originality and quality. And of course, if the more we fight even on the internet with infringements, the more ROI we can get. So after comparing and analyzing all of this, we decided to create our own platform, which is called Gorodissky IP Security. It's a platform that we created and is distinctive from the global ones. Why? Because it is created in the law firm, and it unites brand software developers, brand analysts, and lawyers working all together in one team. The client can first analyze the market, discuss infringements with brand protection team. The brand protection team can prepare the abuse report, which I mentioned, and discuss it with the client. Then they can send different cease and desist letters, which are more or less standard, and that's why they cost less than the lawyer would prepare it from the scratch. And this can be distributed in the automated regime upon fixation of certain evidence. Then, if the 20% which I talked a couple slides before, or 30%, of course, if you ask me, it is left, but then this can go to the hands of lawyers in the same firm, which know the situation, they know the facts of the case, and they can quickly propose further judicial or administrative strategy to apply in terms of IP enforcement. You don't need to stop, as the client, you don't need to stop working with one company and start contract another firm, a law firm, to hand over this 30% or 20% to new people. So it's a combination of software and lawyers that work together and bring more positive result. We provide all types of searches, including keywords, word elements, photos, figurative marks, which not all software can do. And we also have not only Latin, but Cyrillic, Arabic, and other language search systems that help us to work not only in Russia, CIS countries, but in other countries, including Asia, by the way. And again, the client can achieve broader protection and broader enforcement on the territorial level. This was about it. So if you have any questions, please ask right now or during the conference. Maybe later, if you have a question, you can always email us. We work in Dubai right now. We opened an office recently, and we are open for cooperation. Thank you.